quite strong words there from the CJN Olukayode Ariwola, directed at judges of Nigerian courts. There's been a lot of activities at the courts. Some leaving much to be desired. Some others leaving a bad taste in the mouth. Some others, people say, well, kudos to you. The people, they say, are the ultimate judge in these matters. So let's get deeper into this and what it portends for the judiciary and how things can take a better shape in the coming days. We're joined by Mr. Ibrahim Lawal, who is the chairman of the Nigerian Bar Association, Ibadan branch, joins us virtually on the program this morning. Good morning, Mr. Lawal. Welcome to the Morning Brief.
Good morning. Good morning. It's my pleasure joining you once again.
Right. We always need a guide when it's time to talk about the judiciary, even though Nigerians have the laws, the constitution and other laws at their disposal, but you always need some legal, direction. That's why we have you on the show. But just before we get to what the CJN said and the recent conduct of judges in the country, I'd like to first get your thoughts on the court, the ECOWAS court, which found Nigeria guilty on the NSAS protests at Lekki toll gate, found Nigeria in breach of some articles in the African Charter on Human and People's Rights, specifically security of persons, freedom of expression, assembly, and all of that. So the context of this is that African Charter. For you, how enforceable is this? We've seen situations in the past where the ECOWAS court gives a ruling and the Nigerian government does not abide by it. But will this be any different for you from where you sit, at least?
Well, let me first and foremost commend the ECOWAS court for the judgments they have also handed down. And I hope that the government of the day, being a product of judicial intervention and the product of democracy, will also obey the judgment. You see, ECOWAS courts, by virtue of their creation and Nigerian as a sovereign state, it's pretty difficult to predict that Nigerian government will be willing and ready, to abide by the judgment. I just hope that with the kind of person we have as the Attorney General of the Federation, a man of few words and better action, and a man who knows the significance of judicial pronouncement, I am sure that the Nigerian government will abide by that judgment.
Right. Another side of this is a lot of people are wondering, why did it take this long? Almost 4 years, they say. Remember, the NSAS protest was in 2020. For a lot of people, they had even forgotten that there was an NSAS protest. And then all of a sudden, they see this judgment and remember, oh, there was a protest. So why do things like this take so long, particularly because people want justice to be served on time? So, because they said justice delayed may be denied.
And justice, and they should also know that justice rushed can also be justice denied. So you have seen that long period of handing down, judgment is not limited to Nigeria alone. It has taken, see how long it has taken the ECOWAS court to also, arrive at their decision. While I am not an advocate of a delayed justice, I also know that in order to give parties fair hearing, because there are a lot of factors responsible for delay of justice, or where you have to take a lot of time before you arrive at the judgment. There are a lot of issues, stemming from coming from the court itself, coming from counsel, even coming from witnesses. There are times when you go to court, there might be holidays. There might be a time when they will say judges are in the conference. There might be a time when lawyers will not even be ready to give excuses that their witnesses are not in court. There are times, even in criminal matters, when the correctional centers or facilities will not bring accused persons. So it's a lot of factors that you cannot solely lay at the doorstep of the court itself. So it's a lot of things. But what is important is that at the end of the day, does justice serve the purpose for which it is created? If it is, I think it is better than to rush, a case, and at the end of the day, you cannot make sense of what comes out of it. But nonetheless, I'm also of the view that whatever matters that are before the court should be, expeditiously treated, such that everybody will leave satisfied that justice has been served. And it's also going to show, the length of time and the resources we commit to judiciary. In cases where you have few numbers of judicial officers in a particular jurisdiction, how do you expect cases to move swiftly? Like in Oyo State now, we are supposed to have not less than 40 judges. We are having less than 20 judges. And these are judges that will contend with a lot of cases that are filed every day. So there is no way judges will be expeditious in handling their matters unless we are deceiving ourselves. Unless and until we come to terms with the reality that our judiciary needs proper funding in terms of resources, in terms of quality of judicial officers we have, and in terms of the supporting staffs that are working in the judiciary. We'll just continue to, cry, for justice, because we have not been able to do what is expected of us to get, justice.
All right, Mr. Lawal, let's now talk about some of the things that the CJN said yesterday. There are a couple of things that the CJN was referring to. We've had incidents where a court in Rivers gave a restraining order, one in Kebbi lifted that restraining order, overturned it, another one restrained again from Calabar. There was even a case where in the same building in the FCT, Court of Coordinate Jurisdiction gave conflicting orders, one upstairs, one downstairs. We've seen issues where there are jurisdictional overreach when federal high court cases are being heard in state high court and vice versa and all of that. So I wanted to speak to this trend that we see, that the CJN had to speak to this particular one, and what can be done beyond speeches and just demotion or restraining from promotion 2 to 3 years.
Well, let me say that the situation we find ourselves in the judiciary is worrisome, and I am happy that the Chief Justice of the Federation also appreciates the fact that if care is not taken, judiciary might be going, to extinction by their actions and what have you. And my simple answer to this is that we must go back to the mode of recruitment. The problem with us, a lot of people who have done that toga of being a judge, let us also ask ourselves, most of them, what kind of practice do they have before they are elevated to be judges? Judges who practice and understand practice, who appreciate what we call precedent, and appreciate the fact that you cannot, go and adjudicate on matters that you have no jurisdiction. But a situation where what we have, pardon me to use this, is a paddy arrangement where people that ordinarily have no business being in judiciary find their way, into that, hallowed seat. You discover a lot of infractions you see. So, to me, if you want to address this issue, we must look at the process of appointment and ensure that only those who are qualified, who have, evidence of good practice, are appointed as judges. Even when they are magistrates, these are people who have good reputations as magistrates, are elevated as judges. We must do our background check very well. Integrity matters in appointing judges. while I am not saying that those that are there don't have integrity, but the reality is that there are some that all of us know are question marks. And secondly, if you want to, stand this tide, we must, as much as possible, be serious with our disciplinary process. Most of the time, the punishment that we give to any judge are, to me, a slap on the wrist. We do not, if somebody has done a despicable thing, there's nothing stopping the NJC from removing that person as a judge. Outright sack. When you know that if you have put up so many years in the judiciary, and you do not want to toy with it, when you know that the sanction against you is enormous. But when we see the recent past, they slap in the wrist, and that emboldened a lot of them to do what is not, expected of them. And we must not limit it to judges. Even lawyers who file frivolous cases, when you know that a court does not have jurisdiction, why do you have to, steer that kind of controversy? There must also be a punishment, even for lawyers. Lawyers should be able to advise his or her clients appropriately using the law. Most especially, judges must adhere strictly to the doctrine of precedent. If we follow precedent, if all judges follow precedent, law will be certain. You can predict the outcome of the judicial process. But what we have seen in the recent past is the refusal of a lot of them, to follow judicial precedent and thereby commit judicial rascalities. And so beyond lambasting them in the judgment, the effort must be made to also let them, see the consequences of not adhering strictly to lay down precedent. It is very important to our judicial development. If we want to be serious as a people, our judiciary, beyond the call for proper funding, we must be interested in those who become judges in various jurisdictions.
Mr. Lawal, what do you think is responsible? Is it impunity or, as you said, no strong action in terms of reprimand that makes a judge sit over issues beyond his or her jurisdiction? So this is what we've observed as lay people, onlookers. So they bring a case to the judge and they seek relief and all sorts. The judge, perhaps understanding that I don't have jurisdiction over this issue, refuses to speak on the substantive issue, but gives other ex parte, maybe interim injunction or interlocutory injunction or whatever it is, the injunction they give, and that becomes a subject of adjudication, which may be appealed to other appellate court or higher courts. Why do you think they do that?
Well, the thing is that when you discover you don't have jurisdiction, you cannot even make an order, because whatever order you make is without jurisdiction. As long as issue of jurisdiction is the focal point, that issue must be addressed first and foremost. And that's why I said that a lot of people who are appointed as judges do not also have clear understanding of the law. I mean, pardon me that I am saying this, but the reality is that if we love this country, we must be able to tell ourselves the truth. It is born out of lack of understanding of the law, because the issue of jurisdiction, lawyers don't even need to raise it. The court can raise issue of jurisdiction so much that do I have jurisdiction on this matter? And so you now, invite the counsel to address you on the issue of jurisdiction. You can't make an order, whatever order it is, whether it's party, whether it is, until the issue of jurisdiction is resolved. So it stems from lack of understanding of the law and the manner of appointments that we have. It's also a reflection of the fact that those who have done that in the past have not been sanctioned effectively. like the CJ now said, I think that beyond that address, effort should be made to impose heavy sanctions on judges who flagrantly, refuse to follow the law and refuse to also follow the laid down precedent. If you do that, if you know that if you misbehave on the bench, there are, consequences for it. Gone are the days when you say you have judicial immunity, and so you can do whatever you like. That judicial immunity must be defined, and subscribe to a situation where you are acting lawfully. You can't act lawfully when you assume jurisdiction over a matter that you have no jurisdiction. For example, a federal high court does not have jurisdiction over a chieftaincy matter. For whatever coloration you want to put onto it, you do not have jurisdiction on chieftaincy matter. And so if a judge, decide to assume jurisdiction over such matter, it's going beyond, his bounds. And I think the cloak of judicial immunity should be removed from such a judge. That's the thing. So beyond the court, by the Chief Justice of Nigeria, which I so much appreciate, we must follow it by action.
And this conversation is quite important, Mr. Lawal, because a lot of people might say, oh, this is a judiciary thing, up until the point where you are faced with a case in court, and then you have to now go to that judiciary. So this is not just for lawyers or for the judiciary to handle. I think it should be an all people's approach. Everybody should be interested in what goes on in the judiciary. Some have described some of these appointments as, at least the processes, as opaque. They say they don't quite see the main factors used. On the flip side, some have even gone ahead to say there are nepotistic tendencies in some of these appointments. I was reading a report by Gavel recently, and names like the Belgores, Kutigis, Ademola, even the Ariwola, the current CGN, names mentioned, and how they've seen family members also being appointed as judges. So I want to know if lawyers, is this something you're concerned about as well? Is this a trend that you have noticed? And do you think it portends any danger to the delivery of justice in Nigeria?
Well, let me say clearly that I have no problem with the Belgores of this world, the Ariwolas, and the other persons who have become judges. You cannot, because you are related to judges and you have also read law, and now say because you are related to one judge or the other, you are entitled for appointment. No. My own issue is that what is your competence? It does not matter to me whether you are Ariwolas or you are Kutigis or you are Begores. My own is that, are you competent, and do you merit that appointment? Those are the things. It's not about, it's like, telling my daughter who is studying law that he should not be appointed because his father has been a lawyer. That would be taking it too far. But our own is that whoever that wants to be a judge must have the competence, must have the practice. Even if he wants to be elevated from a magistrate to judge, we must make sure that those that we are, putting forward as judges are the first class in their own rights.
That's so who then decides if they are first class, Mr. Lawal?
The issue we have as bar association is a situation where people will just interpret the constitution and say you just have to be 10 years at the bar. We have seen cases where somebody who is a trader, because he was a lawyer for 10 years ago, appointed as judges. We have seen somebody who works elsewhere and become a judge. Those are the things we frown at. It is not enough that you are qualified because you are more than 10 years or you are 10 years before. We must know what has been your contribution to it?
So, Mr. Lawal, who then, and I think it takes me to my next point, pardon me, Mr. Lawal. So who then decides who is competent, Mr. Lawal? It takes me to the next question. Who then should decide who is competent? Do you see clearly how that decision is made as to, okay, this person is really competent? Is that something you are seeing that is being at least done thoroughly?
Well, like I said, in the appointment of judges, the bar supposed to, participate actively. We know ourselves. In every jurisdiction, lawyers know themselves. They practice together and they appear before magistrates and some judges. And lawyers should the bar should be given opportunity to comment honestly on the suitability or otherwise of any persons that are put forward for appointment. And such comments should not just be advised. More often than not, the bar will give comments on the character of certain persons, and the NJC will still go ahead to appoint such persons. It is not good for our system, and that's what we are saying. In fact, in some cases, comments of the bar will not even be sought before appointment. And those are the things that are, contributing to the low standard of judgment we are having in our various courts. So for us, as far as we are concerned, we know ourselves. We know those that merit that particular position and have been denied over the years. We know those by virtue of being they know and become judges who have no business of becoming judges or magistrates. In fact, the worst aspect of it are the magistrates. You would marvel when you see a lot of people at the magisterial level who have no business being there in the first place. And more often than not, most of them graduates to become judges and even judges of Court of Appeal and even Supreme Court. So we need to be fair to ourselves. We need to involve more the bar, and the bar itself should also be bold enough to say it the way it is.
Yeah,
we also have cases of some people who represent the bar,
if I'm a button,
speak the truth.
If I'm a button,
suitability of that right of the person that are appointed.
If I'm a button, as we begin to wind down, so two questions in one. Do you think the NBA is living up to expectation? Let's even use the leadership of Yakubu Maikiu, SAN, for instance. I know the other day it was literally reprimanding either his colleagues or Nigerians, I don't know, talking about how they use one brush to paint the judges, and that not all judges are corrupt, that the number of judges that are complicit in these allegations of being found wanting in character and in integrity are quite infinitesimal compared to the larger population of judges. That's on one hand. So is the NBA checking the judiciary enough as it should on the one hand? On the other hand, do you think that the NBA, the judiciary itself, should experience some reform? Because the CJN is sitting literally on every level of the institution in terms of chairing NJC, chairing this and others. Don't you think that should be unbundled at some point so that to give, spice and variety and fairness in terms of making decisions, just like you alluded to, that sometimes the bar may be saying, no, this person may not be qualified, but they may go ahead to appoint the person.
Well, like I said, when you talk about the NBA is a working group, I must confess to you. And, we have seen, performances of various leaders of the NBA. But the truth of the matter is that, we operate within the law. The law specifies what role each of, the bodies will play. As far as we are concerned, the law made the head of the judiciary as of today is Chief Justice of Nigeria. And what we need is sincerity of purpose. If you have a Chief Justice of Nigeria who is sincere and knows what he wants to do and love judiciary, as the interest of judiciary are at, what will be paramount to him is the competence of those that will be appointed. what our president said, yes, if you look at the numbers of judges that are complicit in this kind of things that we are talking about, they are quite few. But that few numbers are giving the judiciary a party. And why should we even have any numbers at all that will embarrass the judiciary? And that is why we are saying that our process of appointment should be looked into.
Right.
The bar should be given enough room, to also participate in the process. Look at it. In the appointment of judges in the state, the bar does not have a role to play. What you have is the GSC, the Judicial Service Commission, appointed by the governors. So the governor has the prerogative to appoint his friends, even when they are lawyers, and they are answerable to the governor. So they do the duties of the governor.
Really.
But if the law is done in such a way as it's done in NJC, the bar has representative in NJC. Why can't the bar has representative?
All right.
Yes.
But Mr.
So
Lawal,
I will suggest
the deep issues you have raised
at state level.
Right, and it's not just at the federal, even the state levels as well. So we have a job of work for us to do as a nation. Well, all eyes on the Supreme Court today is to see how it rules on the local government autonomy. So it's also a big day for the courts. But we'd like to thank you so much. We've been speaking with Mr. Ibrahim Lawal, the chairman of the Nigerian Bar Association in Ibadan branch. Thank you for your time on the program.
Welcome. You're welcome. It's my pleasure. Thank you.
We'll take a moment now, and when we return, well, you call it rapper, but here in Nigeria we call it rapper. And we're speaking with a man who is tying that rapper, but more importantly, using it to point attention to social issues. And he's always on the run. But today, we've paused him for a moment. So stay with us. It's going to be an interesting conversation with the world rapper man.